ROSARIO, and for the Fifth District of the State of Florida is now in session. The Honorable Ryan D. Lambert, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, good morning. Happy Valentine's Day, and welcome to another session of oral argument with the 5th DCA. As the Marshal just indicated, I am Judge Lambert. I'll preside today, or at least over the first two cases. We have three cases this morning. We'll have a slight panel change for the third case. Let me introduce the other panel members before you today. To my right and to your left is Judge Jay Cohen, and to my left and your right is Judge Jim Edwards. Again, we have three cases today. They are all civil cases, so each side will have 20 minutes to argue their respective cases. For the appellant, I will set a 5 minutes aside for rebuttal unless you tell me that you would like less or more time, and I'll adjust the clock accordingly. If you have any cell phones or any other electronic devices, please either turn them off or put them on silent so your phone or device does not distract from any of the attorneys or the parties when they are arguing before us this morning. Okay, that being said, our first case is case number 18-932, DERICK Smith versus the Orange County Sheriff's Office, Charles DEES and Miguel ROSARIO. So, counsel for Mr. Smith, whenever you're ready.
Good morning, Your Honor. May it please the court.
Good morning. Yep.
Okay, Your Honors, my name is Jerry Gurley, and I am the counsel for the appellant DERICK Smith. This is a case that is before the court on the lower tribunal's grant of summary judgment. Obviously, when there's a grant of summary judgment, the question is whether or not there are any material issues that were in dispute that would have given rise to a jury question. It is Mr. Smith's contention that there, in fact, was a material question, and that question turned on whether or not there was probable cause to make the arrest of Mr. Smith. The facts that we think support the conclusion that there wasn't probable cause is that on the date of his arrest, he was at his home, minding his own business, and a person by the name of Shelley Culler came to his residence uninvited, made her way through the gated area because he lived in a gated community. It is without question, and it is not in dispute, that she came there to confront him about an argument that occurred the day before. She was there to demand that he read a note and to therefore demand that he give an apology. When she saw him, the appellant, he was actually loading things into his car because he was assisting his in-laws in moving from one location to the next. She blocked him in so that he could not leave, and she got out of the car and she confronted him. It is not in dispute also that she brought a knife to that location. So she left her home, which was about 5 or 10 miles away, drove to the appellant's home with a knife.
Isn't the issue what information the police officers had based upon their interview of the witnesses?
Yes, of course, Your Honor. And they had this information, and that's why we think that they had all the information that I'm sharing with the court. So I think that the assessment is one of, given everything that they know, the totality of the circumstances.
Well, they were told that there was a verbal confrontation, correct?
Yes, they were told that,
And
Judge.
she made a claim that Smith physically had made contact with her, correct?
That is correct, Your Honor.
There was some physical evidence that supported that accusation, was there not?
Well, that we dispute. There was a red mark, but whether or not that disputed the contention that she had been pinched by the...
That's what she told the police.
And Mr.
So in viewing this from their perspective, that's the information they had, that there was a verbal confrontation, that he had physical contact with her, and there was evidence from their perspective to support that accusation, correct?
Well, again, I would respectfully disagree because, first of all, Mr. Smith disputed that he actually touched her. Yeah, there was a red mark.
This isn't about guilt or innocence. This isn't about who ultimately prevails. It's about whether there's probable cause.
Yes, Your Honor, there was some physical evidence in terms of a red mark on her neck. However, Judge, I think that when we talk about what constitutes probable cause, as I understand the law, what facts constitute probable cause is a pure question of law if the facts are not in dispute. But if the facts are in dispute, in other words, if there's an A story and a B story, then that gets to the jury. So Mr. Smith gives a completely different explanation of what occurred than what Ms. Cullard gives. But what isn't in dispute that I think that the officer was required to take into consideration is everything that happened that led up to that point.
Well, how do you know he didn't do that?
Well, I think that whether he did or did not pinch Ms. Cullard on the neck presents a jury question. I think the law says that when the facts are undisputed, it's a pure question of law, then the court can render the decision if there are not disputed facts.
So anytime there's an altercation involving two people, if they have a different story, the police cannot arrest anybody?
No, Judge, I'm not making that broad statement. I'm saying that it's a fact-specific analysis and that the officer has to look at all of the facts, every single fact, can't zoom in on one narrow issue. So if the officer...
But I mean, there's no way you could listen to both of these people and reach one set of facts, is there necessarily? I mean, you've got a story here that's kind of... They both have the same core story, that there was an altercation, but one of them tells this, one of them says that, so you could never arrest anybody. There would never be probable cause under what you're saying if there were two different stories on the important part.
Your Honor, again, I'm not saying that, and if the Honors are hearing that, I'm not communicating clearly enough. What I've said is that it's a fact-specific analysis that the officer, using his or her training, knowledge, and experience, has to take into consideration the totality of all of the facts known at the time to arrive at a conclusion of whether or not there's probable cause to arrest.
Well, but I mean, then they're doing it at their own risk, that if they listen to both stories and there's a conflict as to why that injury is there on the lady's neck, and they choose one side or the other, and then the prosecutor elects not to prosecute, that sounds like they're now, in your view, exposing themselves to a jury trial for malicious prosecution.
Well, again, Judge,
that seems like a pretty dangerous
it was just
road to walk.
an even, if those are the only facts that it was known to the officer, because we're talking about what was known to the officer at the time. What was known to the officer is that Ms. Cullard was the initiator and she was the aggressor, that there were two confrontations, one at Mr. Smith's initial place of residence. They convinced her to back away so that they could drive down the road 2 miles, and all of this is in the record. And once they got to their next location, she followed them there, and she produced a knife. There's no dispute that she was the aggressor, that she came to confront the appellant, and she had a knife. The police officers recovered that knife from the vehicle. There was probable cause to arrest her for aggravated assault. She did not get arrested, but the appellant was arrested. So I think that
Didn't your client say he did not want to prosecute her?
Initially, he did, because she...
Wasn't that a good reason for the police not to initially arrest her?
I don't think so. At some point, Judge, before all of the things were done, he did say, I would like to go ahead and prosecute. So they did realize at some point, first of all, they had the facts based upon her confession, to arrest her for aggravated assault.
Well,
in addition to
she
that,
had the knife, but she just like held it at her side or something like that.
There again,
one time she said she had it in her purse. Another time, I think she said she held it at her side or something like that, right?
Well, Judge, what is not in dispute is that she brought the knife, and she brought it in the event that she needed to use it on the appellant. And we have to look at what that should say to a reasonable officer, that she was there for a confrontation and potentially a violent confrontation. They knew that. They retrieved the knife from her, and they did not file any charges against, or they did not arrest her on the scene. But somehow Mr. Smith, who arguably had the right to stand his ground under those circumstances, ends up being arrested.
But he filed charges, the officer filed charges that same day, later that day, with the state attorney's office against Ms. Cuellar for the aggravated assault with a deadly weapon, right? Yeah,
Judge, and respectfully, my understanding of when officers file charges at large, they're essentially saying that they don't want to do it, but just as a general coverage, they have the authority and they have the information, they had all the evidence to make an arrest, a felony arrest, based upon those set of facts that
your guy didn't want her arrested, I thought.
Right. So
let me just. Didn't he tell him that? I mean,
initially, Judge,
okay,
because
so they didn't arrest him after they.
I'm sorry, I didn't mean to interrupt.
No, go ahead. Go ahead.
But before the matter was resolved, if the court looks at the record closely there, he did say, yeah, I want her arrested. The reason why he initially said I didn't want her arrested was because this individual, Shelley Cuellar, is the sister of his fiance. So this is a family matter. He's trying to just say, just let you go your way and I go my way. I don't want any trouble. Don't make any trouble for me, and I won't make any trouble for you. But Cuellar is pushing the issue, and so then he says, look, if we're not going to work this out as a family, then I want her arrested. There was sufficient evidence to make that arrest that was known to the officers before they let her go. And they decided, we're going to just do an at-large charge. So again, what I'm saying is, if you look at the totality of the circumstances, and I think the officers are required not to just focus on one single mark on her neck, one single piece of evidence. And I'm not disputing that that evidence was there, but can we at least give some consideration to the fact that she was the initial aggressor, that she brought a knife for the sake of having a violent confrontation with the appellant, that the appellant was in his own home minding his own business and was confronted by her?
Whether your client has a case or not doesn't really have anything to do technically with whether they arrested her or charged her or not, does it? No,
it doesn't, Judge, but it does go to the fact that my understanding of the law is that when an officer who has not witnessed the quote-unquote alleged crime, he or she has to take into consideration all the facts known.
What fact are you saying that the police overlooked here or didn't take into consideration?
Overlooked the fact that Mr. Smith disputed vigorously that he pinched her. He acknowledged that when Shelley Cuellar swung at him, he slapped her hand away. They are totally playing down the fact that she was the initial aggressor, that she came to his home, that there were actually two separate confrontations, one at the home and then one 2 miles down the road. And in that second confrontation 2 miles down the road, that is where the knife was produced. Whether the knife is on the side, in the purse, a reasonable person under those circumstances would feel that they are in some type of imminent danger when someone has a butcher knife in their hand, and that person is obviously not thinking rationally because they've come to your house uninvited, somehow slipped through the security gates, and is insisting on you reading a letter and apologizing. A reasonable person would feel threatened under those circumstances.
All right, thank you.
Thank you, Your Honors.
Okay, you have 8 minutes. Rebuttal. Good morning.
Please, the court. I'm Walter Ketchum. I represent the defendants in this matter. This is a case all whittled down, malicious prosecution. The charge is battery. So the question is, was there probable cause for the police officers to arrest Mr. Smith for battery? That's the whole issue, because that's the whole question. Was there a malicious prosecution based on battery? And so you look at the material facts, and the salient material facts aren't in dispute. Number one, Cuellar was having an argument with Smith. They both agree to that. Number two, Cuellar said that in that argument, Smith had pinched her on the neck. Smith says no. Quayler says yes. Quayler points to a part of her neck that shows to these police officers' satisfaction a mark consistent with a pinch. That is a battery. The police officers have a right to believe her when she says, he did this to me, he battered me. Mr. Gurley just admitted to you that she did have a mark on her neck, that was a fact and evidence. She said she identified Mr. Smith as the person who put the mark on her neck without her permission or consent. She was willing to prosecute him. She filled out a form, said she was willing to prosecute. She filled out a statement. As a result of that, these reasonable police officers believed that Mr. Smith had committed a battery on her. All this other stuff about knives and arguments, whether on the property or not, doesn't make any difference. The sole issue is battery. Offensive touching without permission or consent. And that happened based on the undisputed facts, at least to the point where the police officers reasonably believed it happened to where they arrested Mr. Smith. Now, did they not arrest Ms. Quayler? No. Why not? Well, a big reason was because Smith said he didn't want to prosecute, and in fact signed a declination to prosecute. He changed his mind in the police car on his way to jail when I guess he decided, well, if she's going to prosecute me, I'm going to prosecute her. So he changed his mind and then said he wanted to prosecute. They gave him a new form to fill out because they had already left the scene, because they were already on their way to jail. They took the form and turned it over to the state's attorney's office for further decision as to what they wanted to do. That's exactly what they're supposed to do. The law is very clear about, and it's throughout my brief, and I'm sure you judges have heard it time and time again, as to what a police officer has the ability to do at the scene. Probable cause is determined by a prudent, cautious police officer at the scene at the time of arrest. It's a fluid concept. You've got to look at totality of circumstances and what would lead a reasonable officer to believe that Smith had committed the act. And in this case, there's no question. There was no question in the judge's mind, and the facts aren't in dispute. Summary judgment is only inappropriate if the facts are in dispute. The only fact that was in dispute is whether he pinched her in the neck. And to the satisfaction of the police officers at the scene, it was established. It does not have to be established to the point where you can convict a guy in court. It just has to be established to the point to establish probable cause. These officers, no question about it, had sufficient probable cause to make the arrest of Mr. Smith, regardless of what happened with Ms. Quayler. That is a red herring that really doesn't have anything to do with this case. It's simply a matter of whether there was probable cause for battery. The record is devoid of any contrary evidence. They admit that she had a mark on her neck, and there's a battery. To their satisfaction, proper arrest, summary judgment appropriate. I'm happy to answer any questions.
Yep. Thank you. Okay, Mr. Gurley, you have 8 minutes and 5 seconds that you can use for your rebuttal.
Well, the only thing that I could add is it's not a red herring to think about for this court, this honorable court, to consider all of the facts, because as counsel properly just stated, how the officers arrive at whether or not probable cause exists is looking at the totality of the circumstances. And the totality of the circumstances.
Well, I mean, if they both agreed that she was waving a knife at him and tried to stab him, and he grabbed her and pinched her neck to avoid that, and they both told her that, then...
I'm sorry, I didn't understand.
Yeah, I agree, to totality of the circumstances. If there was a knife and the officers went and asked your client, well, what happened? And he said, well, she was waving this knife and slashing at me, so I tried to defend myself, and I grabbed her. Right. And then they asked her, that Ms. Quayler, and she told the officers the same thing, and they still arrested your guy, then you seemingly would have a better case.
Well, I guess that's one way.
Malicious prosecution, civil, you know.
I'm sorry, Judge. I'm not trying to interrupt.
No, you're fine. Go ahead.
So that is the material fact that's in
That
dispute.
wasn't the facts that were told to them here.
what was told to them was two different stories.
Right.
One of what was the nature of the contact. Mr. Smith consistently said that she was reaching toward me.
Can't they just choose not to believe your client and think that she's more credible, and that if they believed her, then perhaps she wasn't, I mean, she had a knife in her purse, but she was not doing anything that justified being grabbed by the neck and for 10 seconds and pinched or whatever? And
I think that what they're required to do is to look at the facts and to come to the conclusion that a reasonable police officer would come to, given...
The difficulty, getting back to some of the earlier questions that were asked, is that it's very common in a domestic violence situation that the police are given two conflicting stories as to what occurred. And we ask them to perform a very difficult job, which is to, make determinations as to the credibility and the circumstances attendant to each event that they are called upon to investigate. It's a tough job.
Yes, sure.
And it just seems that in thinking about how you would write an opinion that supports your position, that it's problematic to write an opinion that says if there are two different stories, there's never probable cause.
Again, I'm just trying to make sure that I'm stating it clearly for the record. I realize and I've acknowledged that it's a fact-specific analysis based upon the totality of the circumstances, and putting emphasis on the word all of the facts that's known to the officer at the time that the decision is made to arrest. So, same officers, different scenario, there may be a justification for making an arrest. So, the appellant's position is that it's not that it's never appropriate for an officer to make a call to arrest someone when there's a disputed facts on the scene. The appellant's position is given these specific facts. And what's key in these specific facts is that the person, Shelley Culler, was the initial aggressor and the only aggressor throughout this whole scenario that led to the appellant's arrest. So that's a key fact that I think has not been given enough weight throughout the process. If it was just that they were called to Mr. Smith's house, the appellant's house, and there's two people there and they're telling two different stories, and those are the only facts, then the appellant wouldn't be making this argument to this honorable court and wasting the honorable court's time, but those aren't the facts. The facts are that when this person brought a knife to someone else's home for the sake of confronting them, and there was a confrontation, and that is significant.
Right. All right, I think we understand your argument.
okay.
Thank you, sir.
All right, thank you.
Thank you.